So yes, thanks for organizing this very nice thing, and thanks for having me. As Ulrika said, I'm a lawyer. Here at the Faculty of Law at Lund University. I'm a professor of philosophy of law, and I've been doing for the last 10 years been doing research on legal evidence, and especially on fallacies in that judges, legal fact finders, could be jurors in a system where you have juries, commit especially probabilistic fallacies in legal evidence, and also working on developing tools that can help legal fact finders to avoid these fallacies. And one of these tools is Bayesian Networks. So the traditional approach to evidence assessment, if you go into a courtroom more or less everywhere in the world, is very non-mathematical. Lawyers are people who were bad at math in high school but still wanted a good paying job, so they decided not to become engineers or doctors but study law, and thought that they would never need to think about math again. So they are assessing evidence, and although they are working with probabilities, they don't have any formal language. They do it in a very intuitive way, in a qualitative way, and often very holistically, that they go through all the evidence of the case, and then they kind of ask themselves, well, if we take all this stuff together, well, do I feel like I can convict this guy and send him to prison and still sleep tonight? Well, then I'm going to do it. And the problem with this traditional approach, of course, is that it when you need to think about complex probabilities in this way, you make mistakes. So there are a number of problems with it, but two important problems is, on the one hand, that you do commit probabilistic fallacies. I've just mentioned a couple here. In my research, I have identified 13 different probabilistic fallacies committed in Swedish verdicts where people were actually afterwards, sentenced on basis of these fallacies. I have 3 examples here. Inverting conditional probabilities, a classical fallacy where you would have a true positive, and you would say, well, if the prosecutor's hypothesis is true, the evidence that we're seeing is very probable. So then you assume that, okay, so then probably the prosecutor's hypothesis is very probable since we're seeing this evidence. Other kinds of fallacies include underestimating concurring evidence. When you have cases with circumstantial evidence, where you have lots of things where each thing separately doesn't really prove anything in any strong way, but together they can be really strong because they're independent. Or the other problem, when you're overestimating concurring evidence because you are neglecting the fact that these circumstances are actually probabilistically dependent on each other. So they're not that strong together as they might seem. So these are just 3 examples. And so that's one bunch of problems. Another very important problem is the lack of transparency. I don't know if any of you guys have ever read a verdict. Try it. It's very interesting because you read in systems where you have a jury, you don't have any written verdicts. But in Sweden, we have written verdicts. So you can actually, you're supposed to be able to understand why the court arrived at their conclusion. The problem is that there's always this very suspicious jump at the end of the verdict. the court lists all, well, first we have this evidence, and then that evidence, and then there was a criminal expert, and then we get DNA and all this stuff. And then when they have listed everything, they say, well, considering everything, it's now proved beyond a reasonable doubt that he did it. What? Well, there's a jump here. Why? And then the court gets gets appealed to the appeals court, and they acquit the guy with a similar jump. Well, even considering all this evidence, there still is room for reasonable doubt, so we can't. Why? It's completely non-transparent why one court arrived at one conclusion and the other at the exact opposite on the same evidence. So I've been trying for years to convince lawyers to try to start thinking in a Bayesian way about evidence. And I've been doing it in my research and in my teaching. I have here at Lund University a course where actually my student, it's not a mandatory course. The law program has at the end some courses that you can choose of among, and one of these courses is my evidence course, where all the students are actually taught Bayesian reasoning. And they actually do Bayesian networks. It's a 10 weeks course, and I give them assignments, and you can see how happy they are here when they model the case. I've been on this mission for many years to try to get this kind of thinking into the Swedish legal system. It's the only law department in Sweden that does anything similar, and it's one of the few in the world, actually, because there's a great resistance among lawyers to anything that is mathematical. I wanted to take an example of how this is done using a case which you might have heard of because it's been in the news the last year. The bus stop shooting case in Märsta in Stockholm, which is actually, as we speak, being decided by the Swedish Supreme Court. They had oral hearings before Christmas. The verdict has not yet been delivered. I checked the Swedish Supreme Court's website this morning. We're still waiting for it, but it should be coming any day. And it's one of these gang-related shooting cases that are very much in the news in Sweden. Basically, what happens here is a man is standing at a bus stop in Stockholm, and just as the bus arrives and slows down, another man is approaching on an electric scooter, jumps off, runs and pulls out a gun and starts shooting the man waiting for the bus in the back several times. Boom, boom, boom. He tries to escape. He starts running, tries to escape, but he just gets a few steps because he gets shot over and over again in the back, and he dies immediately. The bus driver, of course, when seeing this, pulls out of the bus stop and drives away. But on the CCTV camera of the bus, the image of the shooter is captured in this frame here. You can see the guy with the gun and the jacket. There are a couple of people around, but they all become very scared when the shooting starts, so they all throw themselves to the ground, and so you don't really get any good evidence testimony from any of them because they don't see the face of the shooter. The important evidence in the case against this guy called Cole, who becomes the suspect after a while in this investigation, and is then the guy prosecuted, are two things. One of them is that the cartridges from the gun left at the crime scene has his DNA on them. The other important piece of evidence is when the police search the apartment where he lives with his brother, they find a jacket which looks exactly like the jacket that the shooter is wearing, this parka-style green jacket. And on this jacket, they find blood stains from the victim and also gunshot residue that matches the gunshot residue on the cartridges at the crime scene. So these are the two important pieces of evidence. And they appear really strong, right? I mean, it seems like an open and shut case, but he has an explanation. He said, I didn't do this. And his defense is that, well, you know, I belong to a criminal gang here in Märsta, which is true. The police know this, and it's well established. And he says, and I didn't do it. It must have been some other guy in this gang, some of my criminal friends and associates in this gang. And the way we operate is that guns circulate. We have certain guns that people use. So it must have been that some other guy in this gang shot the man at the bus stop using a gun that I had used at some prior occasion, and which I had loaded, and therefore my DNA is on the cartridges. And, well, you found the jacket in my apartment that quite obviously seems to be the jacket used, but it isn't my jacket. I live in this jacket, I live in this apartment with my brother. Cole's DNA is on the jacket. But there's also DNA from 3 other unidentified people. And he claims that, well, this apartment was a kind of place where this gang hang out a lot. And a lot of people in that also lived in the apartment from time to time. So it must have been some other guy's jacket. I don't know whose, and he just left it there. It isn't the brothers, because the brothers' DNA is excluded, but there is DNA from 3 other guys. So that's his explanation, his story. So what happens is that in the municipal court in Stockholm, he gets convicted. They say, well, it's proven beyond reasonable doubt that he did it. But in the appeals court, they say, just as my example before, no, there's room for reasonable doubt. Could have been one of the other guys in this group. And now it's at the Supreme Court. This case has been very much discussed. The prosecutors and the police were devastated by the ruling of the appeals court. They thought that he would get convicted. They said, well, how is it possible? And they said, well, they obviously underestimated this concurring evidence. Did they? That's the interesting question. Well, if we want to find out, we can do a Bayesian network. As I said before, there were several other minor circumstances in the case that I've left those out here. So this is just a network of these 2 pieces of evidence, the DNA on the cartridges and the jacket. So we have here a network where we have the parent node, Cole was the bus stop shooter, and we have 2 pieces of evidence here that are concurring. There's DNA on the cartridges, and then we have the intermediate hypothesis here that the jacket found in his apartment with his DNA was the jacket worn by the shooter. And we have these 3 here pieces of evidence supporting that hypothesis, that it does match the jacket on the CCTV images. The victim's blood was on the jacket, and the gunshot residue on the jacket matches the gunshot residue on the cartridges at the crime scene. So then, of course, we need to have some kind of prior here for the parent node. As you see, I have 3 states here of that node. Either it was Cole, the suspect, the defendant, or it was one of his friends, about 10 people in this group, or someone else completely, someone who is not an acquaintance of him. And here in this version, for simplicity, I've assumed that there are 90 people in the third category, or 89. So you get a 1% prior of him being the shooter. The thing is here that it turns out when you run the network, that the third category, the third hypothesis, which in some cases can be very important for the posterior, whether there is 10 or 100 or 1,000 or 10,000 possible perpetrators other than the defendant. In this case, it doesn't really make any difference if we assume that they are 90 other people or 900 or 9,000, because the probability that his DNA would be on the cartridges and the jacket would be in his apartment, if it's someone who is completely unacquainted with him, is so small, so it doesn't really matter. The interesting thing is the relationship between the two hypotheses here, Cole and friend of Cole, one of his criminal associates, because those two are going to, when we start observing stuff here, the probability that he is the shooter will go up and someone else will go down to more or less zero. And the interesting thing is, of course, where does friend of Cole end up here? And we need, of course, to make several assumptions, but there are two key questions here that will basically determine the case. And the first is, how probable is it that Cole's DNA would be on the cartridges at the crime scene if the shooter is one of his criminal friends? And the other one is, okay, how probable is it that the jacket worn by the shooter would hang in his apartment with his DNA if the shooter is one of his friends? Those are the two key assumptions, key questions here. And what I did in this case was, okay, if you want to test these assumptions against the standard of proof, we need to know, of course, what the standard of proof is, and generally, based on mine and other people's research, if you look into the Swedish legal system, it's a probability around 98, 99%. So what one could do here is to say, okay, what answers to these previous key questions would arrive at and fulfill the standard of proof, and what answers wouldn't? What would lead to a conviction and acquittal? And to do that, I here assume two fact finders here, two judges, call them A and B, where A is the prosecutor friendly judge who assesses the concurring evidence as strong enough for a conviction, and fact finder B is the more defense friendly who acquits. So what do they need to assume to arrive at these conclusions? Well, it turns out that if you look at A here, if you assume A to the first question, the probability that his DNA would be on the cartridges if it actually was one of his criminal friends, if you assume a 1 in 100 probability that would happen, and if you would assume a 1 in 500 probability that the jacket would end up in his apartment, although he wasn't the shooter but one in his criminal gang, that would produce a 99.9 probability that he is the shooter. So in order to do what the appeals court did and say there's room for reasonable doubt and acquit, what they need to assume something else. So what do they need to assume? Well, if we look here at these two, 1 in 100, 1 in 500, let's try it 10 times lower. If we have, instead of say 1 in 10 probability, which is pretty high, right? We say, okay, so this is a gang of 10 people, and okay, assuming that he guns do circulate and he has loaded some and other people, that he would be in the unfortunate situation of having his DNA on the cartridges, and just his DNA, not anyone else's. It's a 1 in 10 chance. And let's assume then, with the same factorization here of 10, that it's a 1 in 50 chance that he would be unfortunate enough to find himself in a situation where some of his criminal friends left a jacket in his apartment. And also that his DNA would somehow get on the jacket. Maybe he used it another time, or just maybe he just touched it when we tried to find one of his own jackets hanging nearby or whatever. Then we would arrive at a probability here of 96%. So those assumptions are enough to push it under the probability threshold. But the question then, of course, is, if we go back to the criticism of the appeals court, did the appeals court underestimate the concurrent evidence? Is, of course, are these two assumptions reasonable? 1 in 10 and 1 in 50. Most lawyers I know think that they are too high, that these two probabilities are lower, more in the line with fact finder A, or even much lower than so. So here is what I published this in this article. Those of you who are able to read Swedish, it's in Svensk Juristidning last year, bevisvärdering i bussavplatsmordet, where in this article I do the whole case with Bayesian reasoning, also a bigger network with all the minor things. And I end the article by saying to the Swedish Supreme Court, okay, so here is how you need to structure your thinking. Here are the assumptions that if you make them, you will arrive at the conclusion that the municipal court arrived at. Here are the assumptions you need to make if you want to arrive at the conclusion at the appeals court. Now it's up to you to decide which of these are reasonable, and tell us in your verdict how you arrived at that in order for it to be transparent. So if you're interested, check out that article. I also have a podcast for those who understand Swedish called Öppet Fall, which is a podcast on Swedish legal cases where I talk a lot about evidence and try to sell Bayesianism to lawyers. Check that out as well if you're interested in law. Okay, thanks.